First matter to come before us this morning is in re MJRJ ISIS WWMRR. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning and keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
Good morning, Your Honors, Counsel. May it please the Court. My name is Holly Farah, and I am here today on behalf of the mother of the 6 children, in this case, Cedrina Shropshire. This is a case where mother is arguing that it was improper for the trial court to grant a motion for permanent custody of her 6 children to the Summit County Board of Children's Services. It's a 2-prong test, and mother did not argue with that the first prong of the test had been met. What we're here to talk about today is the second prong, and that's the best interest. When you look at the factors that the court must look at for best interest, first of all, the interaction in a relationship of the children with the parents, siblings, etc., the court found, and there was ample testimony, that mother had a bond with all of 6 of these children, that the children were bonded to each other. Now, there wasn't a bond with the father, and there was no evidence that there were bonds with other family members, but the important thing is that there was a strong bond between mom and the children. It's important to note that these 6 children were in 5 separate foster homes, and none of them were in Summit County. 4 of the children had repeatedly expressed their desire to be reunited with mom. The 2 children that had wished to remain in foster care, Isaac and Isaiah, both had extensive mental health issues, diagnoses. One of them is on the autism spectrum. Isaiah, in fact, had not visited with his mom for close to a year by the time this matter came before the court for permanent custody. The case plan had never been amended to restrict visitation. There were no court orders to restrict visitation. Isaiah, who had been diagnosed with ADD and mood disorder, decided for himself he wasn't going to visit, so he didn't. The Children's Services didn't make him visit. Foster parents didn't bring him to the visits. So not only was he...
What was mom's reaction to that? What did she file or do in trial court with respect to visitations?
Your Honor, there is evidence that mom did not file anything. I was not her trial court attorney, so I can't say what her reaction was, and certainly from a legal perspective, there had been no motions filed. I can't say, in the various review hearings whether these matters were addressed, but I think it is important to note that when the caseworker was testifying at the permanent custody trial and was questioned, even she said it didn't seem reasonable that a child with mental health diagnoses decides, I'm not going to visit mom, and there are no visits for close to a year. So not only was he not visiting with mom, he was having no contact with his siblings either. And I think it goes without saying that this had to have some type of impact on not only his wishes to not be reunited with mother, but his brother as well, his twin brother. They were the only 2 children who were residing in the same foster home. By granting permanent custody, not only are these children permanently, all 6 of them, being divested of a relationship with their mother, but they're also being divested of a relationship with each other. There was no evidence that any of the foster families were fostered to adopt. Again, there were 5 different foster homes in this situation. There were only 2 of the children who were together. The only foster parent to testify at permanent custody was the foster parent who had the 2 boys, Isaac and Isaiah, and that woman testified that they didn't know if they would be fostered to adopt, that that wasn't something that they were prepared to commit to at that point in time. As previously stated, 4 of the children had, without a doubt, expressed their desire to be reunited with mother. In addition, the court found that the children needed a legally secure placement, and there was no way to do that without a grant of permanent custody to the agency. Mother contends that that is an error. Her original case plan had asked for a parenting assessment for her to demonstrate housing and employment. She did have a parenting assessment at Summit Psychological. As a result of that parenting assessment, the case plan was eventually amended to include mental health counseling, parenting classes, and random drug screens. With the random drug screens, although she had only submitted to one and the evidence showed that, it's important to note that even the caseworker testified there had not been any concerns from the complaint on regarding substance abuse. That random drug screen requirement came about as when mother went for her parenting assessment, she had indicated that in the past she had had substance abuse concerns, so that random screen came in through there.
What was the result of the screen? Didn't it show opiates and some other?
It did. That mother testified at trial that she had a prescription for. However, there was never any documentation provided to the court or to the caseworker regarding that prescription. Mother did complete parenting classes, the court found that, and mother did obtain housing. Both the guardian ad litem and the caseworker had in fact not only seen a lease for the housing, but had been to the home, and it would have been sufficient for the 6 children to be returned there. Again, she did complete her parenting assessment. She testified that although she was unemployed at the time, but was feeling better due to her health concerns and was going to be looking for work, she did have a fiance who had a steady job, who was providing for the household, providing financial assistance. In addition, 2 of the children received Social Security benefits, and mother testified that if the children were returned to her, she would also have those funds available. She had been in this home since October 1st, had provided a copy of the lease to the guardian ad litem and to the caseworker, and at the time of the permanent custody hearing, the housing was being maintained, the utilities were all on, the bills were being paid, and she was able to meet the financial
But that
burdens
was
of
the
the household.
fiance doing all that.
That is correct.
And she
That is-
wasn't on the lease.
That is correct, Your Honor. That was the fiance doing that. However, she was in the home, that was her home. There was no evidence that that would not continue to be her home.
And the fiance apparently is not the father of any of the children.
That is correct, Your Honor. These 6 children have different fathers, and the evidence showed, and there was nothing to argue, the fact that none of the fathers had a relationship with these children, that it was mother and siblings. They had the bond, the relationship with each other, and there were no fathers who were involved with the children or who had any relationship. I think the 2 most concerning things, first of all, the lack of visitation between mother and her son Isaiah. To have no visitation for almost a year undoubtedly had an effect not only on mom's relationship with the child, but the child's relationship with his siblings. And I think it can be argued on the child's overall mental health. There was not a lot of testimony regarding why Isaiah didn't want to visit, just, I don't want to visit with mom, and visits stopped. And there was testimony that the other siblings were affected by the lack of visitation with Isaiah, and then Isaac's visitation was eventually reduced to just 1 time per month. So the other 4 children were only seeing one of their siblings, and that was just on a once-a-month basis by the time the permanent custody hearing, the second part of the permanent custody hearing came before the court.
It seems like it's difficult to argue that there was error somehow by the trial court related to the fact that these visits didn't take place when the child refused and mother didn't approach the court and ask for the court to do anything.
And again, Your Honor, I can't explain why mother did not approach the court or what efforts were made on her behalf to resume the visitation. However, when you have a caseworker who is admitting at the hearing that it wasn't reasonable, that children normally don't run the ship, that if there is an order for visitation, the visitation should occur. The visitation was occurring in a supervised setting, so if there were any issues, there would have been people there to observe what was going on, to help with the process. The Family Interaction Center is a wonderful place to visit, and it provides a lot of opportunities for the parents to interact with the children, toys, games, etc. But there are several at all times supervisors there from Children's Services who can monitor what's going on, and a child who has mental health diagnosis just making the statement, who, by the way, is at this point only 11 years old. for that child to say, well, I'm not going to visit mom, and that's the end of the discussion. There are no more visits. He's just not brought to the visitation center, regardless of whether mother approached the court with any kind of motion to resume that visitation. And again, I'm not sure what went on in the review hearings, whether these issues were addressed, whether, it is important to note, I think the case plan was never amended to discontinue the visits, and there were never any motions filed or any orders on behalf of Children's Services that these visits are somehow harmful to the child, that these visits should be discontinued. So you're correct in that mother didn't approach the court, but at the same time, the court never took the steps of discontinuing these visits. So one could surmise that perhaps these issues were discussed in review hearings, and that...
You know, if you read the trial court's order, it sounds as if the trial court took the position that mother wasn't fully committed and you know, went through the, you know, the drug screen, the parenting issues, the housing issues, the employment issues. And so I'm wondering whether it can be inferred that or we can infer that the trial court figured that the mother just wasn't interested in the visitation, and for that reason just didn't follow through, because it was a pattern that was established throughout the, you know, the time of the case plan.
My response to that, Your Honor, would be that there is no evidence that mother did not participate in court hearings. She did submit to the psychological evaluation with Summit Psych. She did complete the parenting classes. She did eventually obtain the housing. She was attending visits. So I think to infer that mother was just completely not engaged over the course of the time, I would argue that I don't believe that the trial court record shows that. I think she was engaged and was participating through the entire pendency and she was visiting the other, 5 children. 4 had weekly visits, and then eventually Isaac's was reduced to once a month. But even with Isaac being reduced to once a month at the request of his therapist, I think you can infer that that had a lot to do with the fact that his brother was not visiting, that those were the only 2 children residing together, and that there had to be some impact from the fact that one child was being transported to visits, the other child was not being transported to the visits, and they were all the way in Willoughby, so it's a lengthy transportation. And again, there were some visits missed by mom, but she also testified that on at least 10 occasions she was, according to her, 7 minutes late and the visits were canceled. So I think the trial court had noted that mother had missed visitations, and opposing counsel in the brief noted that mom missed visitations. However, mom did have an explanation for at least some of those missed, and that was due to being late to the visitation center. Mother did not have independent transportation. She was being provided bus passes, but as we all know, that occasionally the bus schedules are a little bit difficult depending on where you're coming from with changing buses, being there at a certain time. So being 7 minutes late is not, I don't think, unreasonable as far as visitations go.
And counsel, you have just under 2 minutes, and you reserve or continue as you wish.
I will reserve. Thank you.
May it please the court, Kevin D. Martino on behalf of the appellee, Summit County Children's Services, we are asking that this court affirm the trial court's decision granting permanent custody of these 5 children to the agency. With regard to the best interest factors, the agency does not agree with most of the facts as presented by the appellant, but we do disagree with the conclusions that she draws from them. In this case, the mother had her children in the care of the agency twice since 2011. The first time was for 13 months, and then the children came back into care approximately a year later in March of 2013 for this case, and the children have been in custody of the agency at the time that the permanent custody journal entry was issued, approximately 2 years at that point. So these children have spent a lot of time in the custody of the agency. During that time, mother has failed to make substantial compliance on her case plan. She did get her parenting evaluation. She did complete some parenting classes. However, part of the evaluation, the recommendation was for mental health counseling, which mother has not engaged in. The record, as far as the trial goes, shows that mother missed 28 out of 85 visits, including 6 out of 12 visits that were scheduled to occur before the first and second day of the permanent custody hearing. So in this case, the permanent custody hearing, first day occurred, and the caseworker asked that it be extended out another 3 months so mother can show that she is going to be able to maintain and this independent housing, which mother did not ever have housing on her own. It was always with the fiance and him paying the bills. But they did continue for 3 months to see what mother could do as far as housing and mental health, and mother did not make any progress, was the testimony of the caseworker when we came back in 3 months. So the fact is that the journal entry...
What exactly, since we're discussing it now, what exactly was the progress that was supposed to happen in the 3 months?
That mother would engage in mental health counseling, demonstrate that she was going to do that, and she did not, and that she would be able to obtain and maintain some independent housing. Because basically, she had come into court right before the first day of the permanent custody hearing and said that she had this lease and that it was month to month, but the fiance was going to pay all the bills. The caseworker described mother's residence throughout the case as basically transient. So there's nothing in the record to show that mother has ever been able to obtain and maintain independent housing on her own for any period of time in such a way that she would be able to take care of these 5 children. The children are in 5 separate homes. The twins are in, obviously, 1 home together. Regardless of whether Isaiah did not want to visit with mother because of the year that they didn't visit, the fact is that mother missed visitations. There's nothing in the record to support that the visitations were canceled due to her being 7 minutes late other than her testimony. I don't know whether that's a policy at the agency. There was certainly nothing in the record to support that. Even if 10 had been canceled because she was 7 minutes late, there are still another 17 that she missed, plus the 6 in between the 2 permanent custody hearings. There's always earlier buses as well. I understand that taking the bus is not the most efficient means of transportation, but the agency did provide her with bus passes. The agency did everything they could to engage in the process to help mother reunify with her child, and the fact is mother failed to do so. The court case plan was amended to include urine screens, so regardless of the fact that the addition was based on mother's past issues with drugs, it doesn't negate the fact that it was a court order. She failed to comply with it. The 1 screen that she did submit, and she was supposed to submit weekly, was positive. She said she had a prescription. She has never to date provided any evidence of that. So these children have been in foster care for several years, since 2011. They've been lingering foster care. They deserve permanency. Mother has failed to establish that she can comply with the case plan, that she can correct the conditions that have brought these 6 children into the care of the agency twice since 2011. Based on that, the agency would ask that this court affirm the trial court's decision granting permanent custody to the agency.
Counsel, what was in the record, I meant to ask opposing counsel, what was in the record regarding this medical condition that mother allegedly had regarding her, I guess, inability to go outside during the winter months?
I don't recall that there was much in there as far as medical documentation. It just made that statement that she had that issue and that she had not shown how she'd be able to support the kids because she couldn't leave the house. There was documentation in the record, however, that she has antisocial personality disorder, but as far as that condition in the winter, there was not.
There's no medical?
There was no medical record that I can remember, just the statement that she says that she has that and she can't leave the house, and that was a concern for the agency as well, was how was she going to support the children during the winter then if she couldn't leave the house. And she has basically asked the court to, take her at her word, and she may very well believe it to be true that this man that she is dating, engaged to, will take care of her and her 6 children, but he is not the father of any of these children. So it remains that mother has not been able to establish the means to take care of her children, to provide the basic needs without relying on financial assistance of this individual who is not currently married to her and is not the father of any of the children.
And I understand about the independent housing, but I guess I'm thinking if they got married, what would be the ramifications?
Right. And the fact is that she's not even on the lease, and it was a month-to-month lease as far as the evidence goes. So you've got this case planned going for 2 years. She still hasn't maintained housing, so maybe this is the time that she'll get married and, have housing and everything will be fine. But these children do deserve permanency. The case did go on for 2 years and she hasn't been able to do it, so.
And all I was meaning is the agency would view it differently if they were married.
I don't know how they would view it. I assume that they would view it differently, that if they were married and they had established that housing, she would have some rights to it. But right now, it's just, a transient situation that she has engaged in before, and without, making any statement or judgment, she has since 2000 now had these 6 children with 5 different men. This is yet a 6th man, so she hasn't established any real long-term commitment with anyone that we could kind of infer that she would stay with this individual for a long time and be able to provide permanency for these children. If there's nothing else, I rest on it. Thank you.
Thank you, Your Honor. Just in response to a couple of the things that were brought up by opposing counsel, she did miss 6 out of 12 visits before the 2nd day of her permanent custody hearing. She also testified that she had been ill during that period of time. There were no medical records that were submitted regarding her low potassium medical issue. Mother testified extensively about that issue, about how it affected her and her daily life-to-life, but she also testified that she was being treated at the Twinsburg campus of the Cleveland Clinic, and that her situation had been improving, and that she was hopeful that it was improving to the point where she was going to be out looking for employment. As far as her independent housing, she did have housing, and there was absolutely no information that was brought before the court that there were any concerns with the fiance. Nothing was brought up regarding his background, that he would be in any way, shape, or form a danger to the children if the children were to be returned there. She obtained the housing and provided proof in October of 2014, and still had that housing at the point in time when the 2nd permanent custody hearing came before the court. So although the lease was in the name of her fiance, she was still with that fiance. The fiance was still paying all the bills, even though the children weren't there, and the utilities were on. There was no concern, both the guardian ad litem and the caseworker had visited the home, that it wouldn't be adequate for the children. So we could guess at any point in time that any of us are going to lose our housing. However, Mom had obtained housing and had been in there since October of the previous year.
Counsel, I need to inform you you've reached the end of your allotted time for today.
Thank you very much.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you.
Thank you.